how to determine if an estate in the state of Texas needs to be probated. Okay, this is a great question. A lot of times people will go into an attorney's office. The attorney will be like, yeah, you need to probate that estate, and the estate does not need to be probated. However, generally an attorney is going to advise you to probate an estate because I don't want to ever really give advice to not do it, and then later on it needs to be done. Because if I tell you no, and then 5 years later the answer was yes, and you never probated the will, well, the will usually can't be probated after 4 years. You might have a good excuse, like your attorney was an idiot and told you not to. But in our book here that we have, this probate book that I created, step number 8 is to determine if the estate needs to be probated. So I divide this up into a bunch of sections. We got questions, yes, no, and then the action step. Has a will of the decedent been probated? Has a will of the decedent been probated in another state? Okay, so we probate in states. We have federal and state laws. Probate laws, state jurisdiction. And is there property in the state of Texas? Okay, so the answer is yes. You need to do an ancillary probate. The answer is no. Go to question number 2. Is there an urgent need to probate the estate? Do we need to do it? It's like necessity. We don't do things unless we need to do them when it's in probate court. You never want to waste the court's time or waste anybody else's time. So the action step, is there something urgent needed, like paying payroll tax for employees of the decedent? Well, then do a temporary dependent administration. Go to number 3. Okay. So you notice there, just because you do a dependent administration doesn't mean you don't need to keep going. You need to get it turned into an independent administration or a dependent administration that's not temporary anymore. Did the decedent have a will? That's a great question. Okay. If yes, go to 4. If no, we got to go to 9. We got to skip all these because these ones up here are going to be the will ones. Okay, so let's go. Yes, he does have a will. Is there a need to collect assets or pay debts of the estate? Okay, so is there some kind of need that we pay some debts, gather assets for some reason? You might need to call an attorney to really ascertain the answer to this question. But let's say yes. There is a need to collect. Well, I want to go down here because I probably want to open up administration. However, if I don't want to open up administration, I want to do a simplified probate. This is usually in the case you have a wife who has her husband's will and she wants to probate you. We do what's called a muniment of title. Horrific name, but muniment of title. Actually, it's kind of a cool name because most people can't say it, so it makes me sound really smart. So we do a muniment of title, and there's no administration, no executor appointed, no administration. The will just says all the property goes to my wife, and then it will all go to the spouse. Now, this is simplified probate, and you can go to checklist number 7 to help you through it. That's later on. We'll get to that. If there are no assets to transfer or debt to be paid, then you are done. Also, something very important about a muniment of title. You don't need an attorney to file a muniment of title because you're not opening up an administration. If you're opening up an administration, you have to have an attorney do everything with the court because you don't have a law license to represent an estate, even your spouse's estate. I had heard in my law school, I don't know if this is true, a girl drafted a will for her husband before she ever graduated. It was found out, and they gave her a really hard time becoming a lawyer because they said, you did the unauthorized practice of law. Oh my gosh, it's a horrific thing. And that's another thing out there. You want to go do those online wills? Us attorneys are thinking about this. I've never seen anybody do this. But one day, some attorney is going to sue and overturn a will for the unauthorized practice. Well, maybe not overturn the will, but it would cause serious problems. Sue a spouse who creates a will for their other spouse for the unauthorized practice of law. All right. In any event, you don't need an attorney to do this, but I would hire an attorney to do this. If you have assets to do it. If you're poor, of course, just figure it out yourself, spend the time. But if you have the assets to do it, it is easier to pay an attorney $1,500 to do this, and he can get it all done for you very quickly versus spending 2 or 3 weeks of your life trying to make sure you did this right. All right, does the will name an independent executor to serve without bond? Okay, that's another important question. It's an independent executor and to serve without bond. All right, yes, go to the action step. Well, we need to do an independent administration. We'll go to checklist number 7. We'll get to those checklists later on, but we'll do an independent administration. If not, we'll go to question number 6. Do all the beneficiaries agree for someone to serve as an independent administrator? Yes. Well, we can do an independent administration. Most courts, almost every single one, if everybody's coming in and agreeing, this person can serve as an independent administrator, no bond required, the court's going to grant that. If not, then you got to go to 7. Okay, so no. So Tim doesn't want Billy to be the executor. Is there an executor named in the will? So number 1, but is not named as an independent executor without bond. So we have an executor. This is usually handwritten wills or online wills. Someone goes online. Susie Orman will, they're awful. They're just not, they don't know what they were doing when they created them. So go to the action step, all right? So yes, there is. We can do what's called an administration with a dependent executor, which most judges want to avoid. We'll go to checklist number 3 to see that. It will be a different video. These checklists I'll do as different videos later on, but if you get go online and get the PDF, you can just go straight to it. Contact an attorney to do an administration with a will annexed if the answer is no. Okay, so if yes, we're going to do this one. If no, we're going to go to this one. Okay, and I'll get out of that because the probate judges are so different that I don't want to say things and then you go to your probate judge and he says something differently. There are a lot of options available depending upon the probate judge. All right, are you familiar? Now notice there's no 8 in here. I'm an idiot. I'm sorry, I skipped 8. Are you familiar with proceedings in lieu of administration? Okay, so we're going to get into other types of administration. Yes, go to 10. No, well, what they are is like a small estate affidavit, determination of heirship, or a determination of heirship, or heirship affidavits. And we're going to see which one you can do as we go through this. So if the estate is below $75,000, not including the home and exempt property, if it's yes, then you'll go to 12 down here. If it is no, then you'll go to 11. So sorry, I said that incorrectly. If it exceeds $75,000, then you go down here. If it doesn't, then you go to 11. Now this is, when you do a small estate affidavit, it is important that you understand and know what the liabilities to the assets are. Is there enough assets to pay all the debts that are out there? Well, if yes, then, if there is not, then go to 12. If there is, then you do a small estate affidavit. We'll go to checklist number 8, just how you do that. And that'll be a different video. Is there an administration to do? Is there a need? Once again, necessity, because that's one of the questions you have to answer that judge. Is there a need for the administration of this estate? Yes, there is. Well, we'll do a dependent administration. No, we'll do a proceeding to declare heirship or heirship affidavits, one of those two, okay? Now you may have gone through this and you've just listened to me throw out a bunch of legal terms and you have no idea what I'm saying half the time. If you are confused, contact an attorney. If you're not, you understand, you're finished. You know what you need to do. You might need to contact an attorney. You might not need to contact an attorney. But you will be armed now in the attorney's office when you talk to him and say, I've done my analysis. I think I'm supposed to do a small estate affidavit. Can you help me see why that's not a good idea? Something along those lines. And then you can see if you can trust the attorney or not. Okay? But that is our step number 8, which is, do you need to probate an estate?